All right, this is 241136, the state of Michigan versus Christopher Moore.
Good morning, Your Honor. Jessica David for the people, P86743.
Well, Your Honor, Jeffrey Fanta on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case behaves poorly in a courtroom that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate under the judicial canons for me to do.
Hey guys, and welcome to today's video. Right from the start, we see the state of Michigan versus Christopher Moore, with his attorney on Zoom and the judge setting the tone. Moore immediately struggles with understanding court protocol, claiming he didn't get the message about appearing in person. This is an early glimpse of the chaos to come: miscommunication, missed hearings, and the beginning of a courtroom meltdown. The judge, calm and professional, is already signaling that sovereign arguments and excuses won't work here.
It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
Of landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Miss Maudlin, maybe we'll just do it around 11:30.
I think there was another case.
All right, let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Miss Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. Circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Miss Davidova, you're free to appear via Zoom. Miss Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Sorry, go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Miss Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I had asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you in person at the 23rd District Court. Your attorney is requested that you get here a half hour before that hearing at 11 a.m. All right, I'll see everyone tomorrow at 11 a.m.
Next, the defense attempts to recuse the judge based on prior behavior in a landlord-tenant case. The judge refuses, emphasizing fairness and judicial responsibility. Moore's previous antics don't remove the judge from the case. This moment is a classic warning. Courts aren't swayed by theatrics or claims of bias. Sovereign citizen tactics often hinge on intimidating the bench, but here we see how quickly and decisively the judge neutralizes those tactics. It's a clear signal that procedural rules outweigh personal grievances.
Judge Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building. To their knowledge, I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So if he's a flight risk. He certainly, at least appears to be, based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And once he is located or picked up or turns himself in, the court will.
Moore doesn't show up for his scheduled in-person hearing, despite acknowledging it the day prior. The judge issues an immediate bench warrant and highlights the risk he poses. This is a turning point because it demonstrates his pattern of evasion and noncompliance. Court appearances aren't optional. Ignoring them escalates consequences. This clip shows the system working exactly as intended, protecting victims, maintaining order, and holding defendants accountable. Flight risk and danger to the complainant become official concerns that now influence bond decisions.
So we probably have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can handle I'll do the arraignment, yes.
All right. I mean, he needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer. Okay,
so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So Mr. Moore, on this case, Miss Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay, so Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your
okay,
Honor.
well,
We stand muted the formal reading of the warrant on the charges, Your Honor.
Okay, so Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
Correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I was sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and
The prosecutor outlines multiple bond violations, including alleged overnight break-ins, firearm threats, and tampering with surveillance. Moore's previous claims of victimhood crumble under the weight of these allegations. The seriousness of these actions, armed intrusion and threats, is crystal clear. The recommended $250,000 bond plus GPS tether isn't arbitrary. It's a direct response to the danger he poses. The commentary highlights the stark contrast between Moore's self-perception and reality, emphasizing that ignoring court rules and escalating criminal behavior has very real consequences.
Years ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
it's clearly not my fault, ma'am. I was asked a question and I was trying to
telling you.
respond.
All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't
Yes
say
or no?
anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well,
Fine.
let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion? What are you talking about? When did this happen?
Moore fires his attorney hours after they are appointed, creating another chaotic courtroom moment. The judge explains the role of the arraignment: to read charges, set bond, and notify court dates. Moore's repeated attempts to argue or deflect responsibility disrupt the proceedings, but do not stop the formal process. This VO emphasizes how self-representation or attorney disputes rarely help defendants. It also highlights the judge's professionalism in maintaining control and ensuring Moore understands his rights, even as he tries to insert himself into every procedural detail.
Mr. Moore.
Mr. Moore,
Wait.
listen. You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12, 2024. And the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein, and while entering, present in, or exiting the dwelling, Shamani Butcher was lawfully present therein and was and or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons felony firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing, an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to MCL 750-224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon Shamani Butcher with a dangerous weapon, to wit, a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000. DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. Count 8 is weapons felony firearm.
There's
The
no charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right, well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit, a handgun, at the time he committed or attempted to commit a felony, to wit, assault with a dangerous weapon, contrary to MCL 750-227B. This is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence, and the allegation is you did make an assault or an assault and battery upon Shamani Butcher, an individual with whom you have a child in common, contrary to 750-81, parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a 4th offense notice on your information or complaint.
This was all on August 12th at what time, ma'am?
There's not a time on here. It said it's at August 12th.
The arraignment formally lists the charges: home invasion, firearms violations, felonious assault, domestic violence, and habitual offender status. The commentary draws attention to the severity. Combined, these charges carry decades in prison. Moore's interruptions and attempts to blame others illustrate a dangerous pattern of denial and deflection. For viewers, this segment demonstrates the legal reality of habitual offender laws. Prior convictions dramatically increase penalties, making the case far more serious than Moore's theatrics suggest. This is a textbook example of why listening to the court is critical.
1995, he was convicted of the offense of stolen property, receiving and concealing in excess of $100 in violation of 750.535A in the Detroit Recorder's Court for Wayne County in the state of Michigan. Listen. And on or about 2/16 in 1996, he was convicted of the offense of breaking and entering a vehicle to steal property over $5 in violation of MCL 750.356A-B in Detroit Recorder's Court for Wayne County in the state of Michigan. And on or about December 9th of 1999, he was convicted of the offense of police officer fleeing 3rd degree in violation of MCL 75047